Коллеги, добрый день. Давайте начнем.
Colleagues, good afternoon. So let's start. Thank you for your attention. My name is Alyona Kucher. I'm a candidate of law and I'm an associate professor of the civil law chair of the university and a partner of company DeBevoise and Plimpton. And today we are going to discuss cross-border bankruptcy and liquidation, and we're going to discuss whether it's working, not working, why it's not working, number of jurisdictions. And first, I would like to introduce our speakers. Judge Ruxo is a judge. He is specializing in transborder bankruptcies and reorganizations in Colorado district, and he is going to discuss that. And as far as I know, they've been working these issues more than 20 years, also in close cooperation with Russian scholars and Russian judges. Yelena Mohova, candidate of law research, so chair of international law of the Russian Academy of Justice, and also she is cooperating with the Supreme Commercial Court of the Russian Federation. And Yelena, she is one of the most reputable scholars in Russia who writes about transborder bankruptcy, and Yelena is going to make the presentation. Also, Ivan Glagolev is head of the legal service of Polus Zolota company, and there was a reverse takeover procedure, and this company moved from Russia to Jersey, and we'll be really interested in hearing the practical vision of the head of legal who actually himself he tested it all. Also Rodrigo Kiselian, one of the leading lawyers in Brazil, and he is working in 15 out of 20 major transborder bankruptcy as in Brazil, and he is looking at the assets of the companies in different jurisdictions, and including those assets in one single process of bankruptcy, which is also an important issue. And Dr. Peter Wand is a counselor of DeBevoise and Plimpton. He's specializing in corporate law of Europe, including transborder reorganizations, and he is going to speak today about the companies moving from jurisdiction to jurisdiction inside Europe. And we're going to have two parts of our panel. The first one is going to be dedicated to voluntary reorganizations. And the second part is going to be dedicated to bankruptcy, also reorganization in the framework of bankruptcy, and the company is working in different jurisdictions, or whether assets are in different jurisdictions when the bankruptcy procedure is going on. And I urge you to ask questions also during the presentations, after every presentation, after every part of our panel discussion, and of course we'll have our discussion by the end of the session. Let's make it as interactive as possible. So if you have any questions, please raise your hands. We'll be happy to participate in more interactive communications. And if I may, I would like to start with transborder organizations in Russia, and maybe we can set the tone to our further discussions. We'll have to deal with the terminology because even our speakers, we needed some time to understand each other, to understand what kind of terminology we're using, what reorganization is all about. And maybe the right thing is to look at the business goal before we provide any legal definition. We must look at the goal of the company. Why is the company moving from jurisdiction to jurisdiction? And then we can find appropriate legal mechanisms. That's why today we're not going to discuss a reorganization proper in the narrow sense of the term. It's not just corporate reorganization and corporate restructuring, and we're going to look at it more broadly. So the process of bringing business of the company from one jurisdiction to another jurisdiction, and business is also going to be interpreted broadly here. When business is transferred from one jurisdiction to another by way of creating the new company and providing the some of the assets of the company it's succeeding. And in the framework of our discussion here today, we're going to discuss classic forms of organization. We're going to talk about M&A, and also we're going to talk about classic restructuring. But then we'll also discuss non-classic forms of reorganization. For example, when companies are just changing the place of registration, and if it happens inside one jurisdiction, but if it's a transborder, and in this case it's a serious and quite a complicated procedure that we're going to consider reorganization. And then let's have a look at if we started with the Russian jurisdiction, transborder reorganization, does it work in Russia? And when we're talking about moving of business from one jurisdiction to another jurisdiction, we should look at the freedom of movement of capital and the freedom of registering legal entities. And in Europe, that we're going to discuss a lot today, because Europe now is at one of very advanced stages regarding transborder organizations, and when we're talking about legislative and practical foundations. So those freedoms are mentioned in the European Union treaties, and also in specific court rulings when the organization is conducted outside the framework of the directives. And those two freedoms allow the European companies at least to hope that they can move business from one jurisdiction to another jurisdiction, and they can refer to their freedoms if they encounter any obstacles. And these freedoms are also respected and protected in Russia. But does this transborder organization work in Russia the same way it works in Europe? We, Russian lawyers, we know that inside the company to conduct reorganization, it's a real headache. And till recently, we had the myth. I remember about 10 years ago in our practice, when the foreigners said, well, let's have corporate reorganization, Russian lawyers said no. It's so complicated from the logistic and point of view, and it takes so much time, and you can never predict the result. But when it's not inside one jurisdiction, when it's something international, it becomes something that is very next to impossible to achieve. And when I'm asked to articulate 3 or 4 main problematic issues that we encounter, I could have the following list. First is the problem of correct transfer of property, so that's the conversion ratio. The second is protection of rights of creditors, because when we get the assets and liabilities of one of the companies, well, here we have to protect the creditors. And number 3 is the protection of minority participants that disagree and believe that their interests are violated. And number 4 is also interconnected, because there are the mechanisms mechanisms of challenging the reorganization, because it's going to influence not just the company, but a large number of the third parties. So those four problems in Russian law, even inside the country, when reorganization is going on inside the country, they become so complicated. And as you know, just recently, we had the changes adopted, serious changes regarding legal entities. Mostly those changes were positive changes, and they were adopted, and they're changing the approaches to these four issues, four problems. If we compare ourselves to Europe and the U.S., we are in the kindergarten, at the kindergarten stage. We try to understand what's going on inside the country, how to deal with the creditors, and just one of the changes that just got adopted, for example, the creditors, when there is just a transformation of the company, the creditors don't get the same rights. Or now at the level of the law, we have this provision that the creditors could be dealt with beforehand, and there is some predictability if you reach an agreement with the creditors beforehand, because the nature of such agreements was not clear, and any organization was dealing with a lack of predictability. And we're trying to deal with the basics before we get to transborder issues. And of course, when you get transborder organization, everything is multiplied by the number of jurisdictions involved. Because remember Article 1202 of the Civil Code. This is the process which is regulated by the legislation of the country participating in reorganization, and we have to apply all the laws that are involved in this organization, and the problems they are multiplying, mushrooming, at least technically and also conceptually. And then we encounter the taxation issues, taxation consequences, because inside Russia everything is more or less simple. But when we think about tax consequences regarding transborder movement of business, it's an open question, very complicated question. And then number three, and which is one of the main bans in Europe, that's protection of the rights of employees of the companies to be reorganized. And the question is whether it's possible to deal with these problems at the national level without supranational regulations. And my conclusion is no. If we look at the European experience, only now the procedures of transborder mergers started working, and the work started in 1965 when the first convention on transborder organizations was outlined. The first draft was published 8 years after the beginning in 1973, and that draft has never been adopted. And in 1978, the directive regarding internal mergers of public companies, but for other companies the procedure didn't work. Then another wave started in 1984 to have some supranational regulations in Europe, and still it was a failure. And only in the beginning of the century, when the notion of European company emerged, and the national legislations started moving together, there was an opportunity to outline the directive, and which was adopted in 2005, and Peter is going to talk about it today. But this directive doesn't cover all the forms like redomicile. It doesn't cover, and the Europe is working at the directive that could regulate redomicile procedure, so that issue is still under work. And transborder organizations that the directive could be applied to, but still 2 more directives regarding the employees and the tax consequences, and only this comprehensive approach towards supranational regulations allowed Europe to start transborder moving of business, which could be more or less predictable, because the attempts were made before that, and there were referrals to the freedom of movement of capital, and then the procedure is quite technical when it's better not to refer to general freedom, but have something more specific to deal with.
So Peter will tell us about Europe in more detail, but I refer to just to show how complicated it all is. We have no supranational regulation in Russia at all, and now we are reforming our civil code, and so transborder reorganization is also missing there. So, and I want to show you this book on European transborder reorganizations. This is one of many, and they consider taxes, corporate problems, national legislation, and whatnot. So I hope that our doctrine will work someday, and this will give a basis to us to adopt any regulation. Otherwise, transborder reorganization, because of differences in the procedures and gaps in the legislation, it won't work at all. Redomicile is a separate type of reorganization for business, and I think that our European colleague will give us more detail on it. But redomicile underway now is due to the fact that there's no unified approach to law. There's a law of incorporation and the law on regulation. So it's a way of playing in between the two in order to move from one jurisdiction to another. Because if incorporation law is applied only, then redomicile without any supranational regulation would be impossible, because we cannot liquidate the company in one jurisdiction and then move it to another without simplified procedures. In Russia, we're just in the very situation because we stick to the criteria of incorporation, and we say that our law is related to the domicile, to the registration location. If you change it and move it to another country, so first you should liquidate it in the first country. And without any special law which would say that it is possible, the procedure becomes impossible. While for incorporation reorganization, it is possible, because the major problem is a lack of alignment of procedures. And there may be 3 or 4 jurisdictions involved. In this case, the problem is not just practical, but just impossibility of redomicile at all. So that is what I wanted to tell you about Russian law. So perhaps it's a little bit unstructured, but I'd like to give the floor to Ivan, and we moved from Russia to Jersey, and I'd rather put 2 questions to him. So the first question is there any type of transborder reorganization which you believe logical to be implemented in Russian legislation? Because it doesn't work here at all. And what practical problems are there? Because you're a real practitioner and you can describe practical problems the carpenters encounter in this area. Thank you for your questions. From my practical experience, I can say the following. Our company has moved from Russia to Jersey. That's true. And the Jersey company listed in London was chosen as our basic platform. The procedure is not simple, but it's rather mechanical in nature, and in principle it is quite possible to implement, and there are no problems with that. But what I'd like to stress is that in such transactions, besides rather numerous requirements in terms of information disclosure and the structure of capital which is required by the jurisdiction the company is moving to, we should also pay a lot of attention to tax consequences, because in all the jurisdictions in which the company is represented, there may be unexpected tax consequences. And besides tax consequences, we should also emphasize various additional charges and duties which may arise in new jurisdictions. Mostly it goes for shareholders who should automatically move to the new jurisdiction within the framework of the transaction. But there are such things as stamp duty which should be paid in the new jurisdiction and which may threaten the rationale of this move, because there may be a lot of other procedures involved and expenses as well. As to re-domicile, this is a very interesting institution which should be implemented in the Russian legislation, in my perspective, because taking into account the trends in our legislation in terms of de-offshoreization, or making companies come back from offshore jurisdictions. So we wonder how it is going to proceed and what will the final outcome be. So the procedure of re-domicile would be really very useful, and I believe that it will be in demand because it may become an instrument to be used by our legal community. We will learn how to use it rather quickly and will be using it. So currently, we encounter the offshore jurisdiction allowing re-domicile, whatever it may be, moving from one jurisdiction to another without putting an end to the legal entity or to the domicile in the first jurisdiction. Well, I can recall that the first precedent of re-domicile emerged with Crimean companies, because those that were Ukrainian before, formally, they became Russian companies. So it was signed, and that's it. It was done by simple signature. So it should be easy to stop being legal entity in one country and to move over to another. But so far we have no complicated or effective instruments. It's a matter of the future. So we mentioned Europe. Let's ask Peter Vand to tell us how it works in Europe, how business moves within the European community.
Thank you very much, Alyona. Ladies and gentlemen, Alyona had asked me to summarize the book she has just shown the audience on 3 slides. I failed. I've prepared 6 for you. And on the basis of those 6 slides, let me take you by the hand and guide you through some aspects of cross-border reorganizations in Europe. First, I will give you some background. Alyona already mentioned the problem of the incorporation theory and the real seat theory and what that means for cross-border reorganizations. Then I will talk about the cross-border merger directive, other forms of cross-border reorganizations, and finally I will briefly touch on tax. The issue. We're all aware of it, but I think it's important to say very clearly at the beginning, companies are creatures of national law. Corporations come into existence because national legislation recognizes them and stipulates what needs to be done in order to incorporate a corporation. The national legislation applicable to the corporation then says how the company is functioning. This is a so-called lex societatis. And there are two main theories how you determine the law which is applicable to a company in a cross-border context. This is not a corporate law issue, but a private international law issue. First, there is the incorporation theory. You move the headquarters of a company from one country to another, and that does not have an impact on its legal personality. It continues to exist. Russia is following the incorporation theory, and many other countries as well. And then you have the real seat theory. If you move the real seat, the headquarters of a company across borders, it loses its legal personality. That's an approach Germany is following. So what does that mean in practice? We've heard about the example of a Russian company moving to Jersey, and that was based on the incorporation theory. If you move a Russian company headquartered in Moscow to Berlin, what happens? Well, it continues to exist from a Russian law perspective, but what will German courts do with it? The answer is simple and terrible from a business perspective. Germany will recognize a Russian limited liability company as a German law civil partnership. That means unlimited liability for its shareholders, since they are now deemed to be partners in a civil law partnership. This is not something your client wants to hear from you as a lawyer. It's a huge impediment for cross-border reorganizations, for the freedom of establishment, and for the free movement of capital. The European Union saw that very early, as Alyona explained, as early as in the 1960s, but it took the European Union a while to get its arms around it. What we have now is a limited harmonization of European company law. It's based on several directives and regulations, and we have, and I will come to back to that later, the treaty on the European Union, which to some extent is a constitution and helps us to bridge gaps in the harmonization. The focus on that harmonization is not only on corporate law, but also on important other issues, and we already discussed a few. It's tax, it's employee participation, but it's also accounting and other issues. But still, Europe is a patchwork rug. European company law works like the blanket on the screen. It keeps you warm, but it's made of pieces. It's made of national legislation, and it's only sewn together, yeah? And I think now the seams hold. They hold the little pieces together. And how that works, we will discuss now. sorry. We have the cross-border merger directive. It took forever to agree on it. It's the result of a very lengthy process. And as Alyona stated, what was key to the success of the cross-border merger directive was the harmonization of the domestic merger regimes by the domestic merger directive in 1985. Only after the member states had national legislations which were somewhat similar, member states could go to the next level and agree on a cross-border regime. So first, national harmonization, and then cross-border harmonization. The scope of application, well, you need to have companies which are eligible under the directive. Those are limited liability companies. They need to have their seats in different member states, and basically that's it. If those preconditions are fulfilled, there is a procedure, a workable procedure. How does the procedure work in detail? On the corporate side, it's simple. The directive says each merging company is governed by the provisions of its national law. So you do whatever is required from a national law perspective. You have a limited liability company in the UK and you have one in Germany. You want to merge the UK limited into the German limited liability company. So on the UK side, you do whatever is required in the UK, and in Germany, you do whatever is required in Germany in terms of shareholder approval, security for creditors, valuation exercises. You do whatever is required under national but harmonized legislation. That applies also to employee participation, which is not so much an issue in the UK, but it's a big issue in Germany. And then we look at the competent national authorities. There are two levels of review. The UK company would go to the competent national authority in the UK. The German company would go to the German commercial register and file its application to merge there. Both national authorities look at the national requirements, which makes sense. Why would a German judge look at requirements in the UK? He doesn't know what they are. So national review at the first level. And at the second level, when the UK competent authority has finished its work, it would send it to the German court, which is competent because the surviving company is based in Germany. And it would recognize what has been done in the UK as valid and sufficient from a German law perspective. But Europe is not only a patchwork rug, also when it comes to cross-border mergers, but there is room for improvement. And currently, the EU Commission is looking at certain areas where the procedure, which has been in place for a couple of years now, can be improved. One key issue is the lack of harmonization in respect of valuation methods. You need to value the assets of both companies in order to come up with an opening balance sheet. So here you see it's really complicated. It's not only corporate law or procedural law and conflicts of law and tax law and labor law, but it's also accounting. And you need to work through these problems one by one when you think about coming up with a suitable cross-border regime. The cross-border merger directive works. And that's why it's used also to achieve results which are or were not intended initially. As I said, the focus of EU company law is on limited liability companies. And the cross-border merger directive only applies to limited liability companies. So what do you do with a partnership? You can still apply the cross-border merger directive, but you first need to transform the partnership into a limited liability company under national law. And then you follow the protocol. Yeah? So lawyers tend to be creative, and once they've found something which works, they tend to apply it also to other scenarios as a workaround. What else do we have in the EU? Well, you can also achieve cross-border mergers under other regimes, in particular through the formation of a European company, a so-called SE. The problem with that regime, which was the way to go before the cross-border merger directive came into effect, is that you're stuck with an SE as a result of the process. But it's a valid alternative. Another valid alternative, when you want to transfer a registered office, a headquarter from one jurisdiction to another, is also to rely on the regime, on the harmonized regime for a European company. The problem is, you need a European company. And then you can rely on the treaty. And you all have heard the decisions before, Centros, Überseering, Sevic. The European Court of Justice decided in many cases that although the cross-border merger directive was not applied, or was not in effect at the time, a transfer of the seat of the company from one jurisdiction within the EU to another has to be recognized on the basis of the European Treaty. The problem with that is that the quote-unquote Constitution of the European Union allows you to do that and requires national authorities to recognize the result. But as a judge or a public official in national authority, you don't know how it works. It's like asking a lawyer to draw up a contract on the basis of the Constitution of Russia and not on the basis of its civil law. So there is a body of law out there, but the practice cannot wait until the court has decided. So if you ask me to give advice to my client, I would always say, apply the cross-border merger directive. It's a clear set of rules, and it's not advisable to rely on the treaty. And then there are other cross-border restructurings which I will not discuss in detail. One last point on the next slide, which is a tax framework. It's very important when you move a company from one jurisdiction to another, if you merge a company, that the result is tax neutral. Because the last thing you want to do is to pay tax on all your hidden reserves when you don't have the cash to do that. The tax merger directive helps here, but it also leaves a lot of questions open. And I will finish with giving you an example of the type of questions which are still open. Let's take the example of the UK company which merges into the German company. In the UK, you have production facilities which will remain in the UK. And the taxes on the hidden reserves are carried forward. It's tax neutral. Yeah? So nothing will happen on that end, except for one thing. The self-created intellectual property is deemed to have moved to the new headquarters, to the headquarters of the surviving company. the IP leaves the UK and the company has to pay taxes on the IP, on the hidden reserves of the IP. And that, take the example of the pharmaceutical sector, can lead to a result where the companies decide not to go for the merger. We just had such a case. So thank you very much for your attention, and I hope that has given you a good impression of the patchwork regime we have, but which is workable.
Спасибо большое, Питер. Если Европа говорит, что у них...
Thank you very much, Peter. If you are talking about the patch blanket is applicable in the European Union, then I would say that in other jurisdictions or other countries we don't have similar regime. We just finished the discussion of the voluntary reorganization, and now we continue the topic about the bankruptcy reorganization. If anyone has questions to the panelists, please do not hesitate. So far we don't have any questions, and of course we are going to discuss at a later stage all these issues. I would like to give the floor to Madam Mokhova to tell about the transborder bankruptcy. Practically the same problem, the lack of proper legislation or maybe comparability of jurisdictions. So does this process work in Russia? Good morning, dear colleagues. I have prepared a small presentation. I hope we will manage to put it on the screen. Let's at least try to do so. So, I would suggest that we discuss some aspects of the transborder bankruptcy. And as a basis of this, transborder bankruptcy is the situation when the assets of the bankrupt has his assets are all allocated in different countries, or they have different jurisdiction. So we have two or more jurisdictions which are applicable to the question of insolvency or issues related to the insolvency. That could generate a number of issues which we are going to discuss later. In Russia, this topic has not been properly developed. Alyona demonstrated a fundamental book dedicated to the reorganization issues. In the Western countries, there are a lot of books of a similar size. In Russia, we just trying to seek this level so that to create a large-scale framework, a legal framework, and I would urge all the colleagues to join this, to think about the transborder, cross-border bankruptcy, and maybe to present their own opinion. I would suggest that we should construe our discussion in the following manner. The transborder insolvency and bankruptcy could be split in the global issues and artificially of local nature issues. It doesn't mean that they are simple, but maybe they are quite familiar to the practitioners in Russia. Each time we talk about the global issues, we should always remember about three elements. This multiplicity of the production with respect of the same debtor or different companies which are the parts of the same group. So we see that several companies are engaged in the bankruptcy case. That could lead to the situation. So we have two cases which show difficulties or challenges on their way. So minimization of the costs of the assets. KPN Quest, it was recognized insolvent. It possessed the cable which went through different European companies. A German company possessed the German part of the cable, a French one possessed the French parts. when the cases or litigations started in different countries, and this cable was considered in by parts. So cable going through different countries, and the other thing is when it was considered by parts, so the assets were diminished in costs. The other thing is when we managed to realize, despite losing the price of the costs of the assets. This is the case of Collins and Aikman. It involved 24 companies. The main production, or the main case, was started in UK, and many US companies refused to launch cases in the United States, secondary cases in the United States, even taking into account that these creditors would be in a more favorable condition if they had launched this case. They refused to initiate the case so that to combine all the assets under the same jurisdiction. This strategy was quite favorable and beneficial for the creditors because the sale of assets, according to the expert assessment, exceeded all the experts' assessments, and the secondary creditors found themselves in a win-off situation. So that this could lead to the segmentation of the assets, and we need to set up specific tools in order to overcome the possible minimization of the assets. These are the coordination of the different or various production. We discussed this issue regarding the Lehman Brothers case. This is the hugest bankruptcy so far. So 75 cases were started under 16 jurisdictions. This is quite a notorious case in the framework of this huge number of bankruptcies. The administrators concluded the agreement on cooperation in order to coordinate their actions in the framework of this, or in the context of such a huge number of litigations. In Russia, so far, we don't have a legal tool to conclude such protocols of cooperation. If we talk to judges on these cases, they always ask what is the legal force or legality of these protocols, what do they represent, who is going to conclude them. So far, the Russian Federation could only follow this legal procedure, and so far we don't have these tools to coordinate the litigations or cases. If the need be, and Russia would be involved in huge bankruptcy cases, maybe in the future this issue would be in the front line. We have Institute for Legal Assistance, but it's not specialized. That is why the foreign experience is quite interesting. The second global problem is the foreign shopping and bankruptcy tourism. This is quite a relevant issue. You heard Mr. Kirkman's bankruptcy, who is the owner of the fruit selling companies. And the Russian Federation is involved as of today into the competitive issues and migration of bankruptcies. So the company initiated in a UK court the insolvency case, and having the decision of the UK, so in all other countries where this decision is applicable, so they would be protected from the decision of the Russian courts. Maybe not against individually this businessman, but maybe with respect to the company which had some difficulties in Russia. They can be prosecuted in terms of subsidiary responsibility, and so Mr. Kirkman would like to protect his own assets from the Russian prosecution, and he initiated the litigation in the court of the Great Britain. So just to realize the scale of this foreign shopping, I would like to cite the decision of the UK court. He says that he can start insolvency proceedings if creditors could have some advantages or feel some loopholes, legal loopholes in this case. So from a Russian prospects, if we don't have the optimum legal regulation and foreign countries do have this, then it could be regarded as a factor which gives the possibility to the foreign courts to start insolvency procedures. This is a huge potential in terms of selection of jurisdictions for the debtors, and we see that after this case, Russian Federation cannot ignore these processes, because the huge creditors appealed against this case, like Sberbank, and they try to convince the court that Mr. Kerman is a bankruptcy tourism, since his business is located in Russia. Some assets, but courts objected to that and objected to launching appealing procedures. So Russia is involved in this process, and shopping relates to both foreign debtors and foreign creditors. This tourism is justified by the overlapping of different jurisdictions. Each jurisdiction determines the limits with respect to the debtors which can be regarded as debtors in their territories. We are talking about the regulation 131/2000, which provides for specific rules regarding the legal procedures which would be initiated in the territory of those countries where the main assets of this debtor are located.
Well, it seems to be great, and Europe found some way out, and there is a similar provision in the unilateral model law, and the U.S., UK, so they all use those provisions from unilateral model law, and it must be the end of forum shopping. But in real life, when we analyze that, we find more potential for forum shopping. There is a presumption that when it's proved that the debtor was conducting business and managing business from another country, and it's evident to the creditors, it's like an open headquarters, and in this case, Kobe was in that so the nerve center of the company, location of the nerve center of the company, and even incorporation is not stable. But what about transfer of the headquarters from country to country? It's a mobility criterion, and it started leading towards the situation when management of the company, which is aware of the financial situation, started transferring headquarters from country to country, and the UK became oasis for bankruptcy tourism. And in the beginning, Great Britain switched the jurisdiction to its benefit. Why is it bad? Well, the company is getting the credit using some interest rate, for the creditors, and then just before the bankruptcy, the picture is changing, and the bankruptcy law became pro-debtor. And if the creditors knew that beforehand, they would be acting differently. And this is just one of the aspects which is changing the picture for major players in business, and we have to take that into consideration. Bankruptcy tourism is making it much less predictable for every party. And now let's get to Mr. Kehanin's case and bankruptcy tourism. Well, in many cases, as experts in Europe say, it could lead to some advantages. And there was Eichmann case when there was just one procedure in Great Britain, and wise use of certain tools such as cooperation protocols provides some advantages, and movement to jurisdiction like Great Britain was ready to take into consideration the interests of all the creditors, and it was positive influence at general revenues and the general outcome. There are positive and negative features, but while we don't have clear legal regulation, most probably we're going to be suffering from the migration of debtors because it makes it not predictable. And now a couple of words about the Russian Federation. And here we're talking about maybe local transborder bankruptcy, not less complicated, but what are we talking about? We're talking about very simple questions that we might face in any bankruptcy case. For example, applicable law. If there is some kind of foreign law which is applicable, foreign creditors, foreign law, and then we're going to discuss applicable law, bankruptcy law, and those cases, they don't create lots of lawsuits, lots of coordination, but it's all trans-border bankruptcy. And in Russian Federation, when we're discussing reorganization issues, we can apply civil code somehow. Transborder bankruptcy cannot boast of any achievements. There are some articles where transborder insolvency is mentioned, that's all. But a lack of legal regulation, of course, doesn't isolate us from the world. That means we have some judicial practice, and it happens from one specific case to another specific case. And the cases make it all the way to the highest courts, and then certain positions emerge. It's positive momentum, but still we're talking about no predictability. Predictability is at its lowest for all the participants, for those who can encounter transborder bankruptcy. And talking about Russian Federation, there are four main questions. So the question regarding the competent court, applicable law, cooperation of courts, and recognition of foreign bankruptcies. That's a very simple picture. And in the Russian Federation, we have we almost have answers to two questions. And I would like to ask the moderator, do we have more time? Is it possible to look at specific cases more in detail? Okay, first let's talk about the answers to those two questions that we encounter. The very first cases in Russia, so those were the cases of recognition of foreign bankruptcies. And what happens if the assets are in Russia and the bankruptcy is abroad. And in Russian Federation we have quite a closed regime, and I'm sure that we all encountered the questions regarding the recognition of foreign rulings and also arbitral awards. And this is a problem which also regards the insolvency cases, and the federal law on insolvency and bankruptcy is providing the special provision, and in the absence of international treaty we should apply reciprocity principle. It's a big advantage, but how are we going to prove that reciprocity? How are we going to prove that Russian bankruptcies are recognized abroad, and so on? And we don't find the answers to these questions, but part of transborder bankruptcies that are covered now, it's the problem that the court rulings are introduced, but those are just the final rulings regarding the bankruptcy. And so we're talking about the court rulings, and that was, for example, when Ukrainian court makes the decision regarding moratorium, and it was not recognized in the Russian Federation because this is not the judgment of the court, not the final judgment. It's a very dangerous attitude, because if we look just at finality of the judgment, it doesn't make any sense for debtors, for creditors, because the assets are not going to exist, and it doesn't make sense to get that recognition. But the solution could be found here, and the judicial practice could deal with it, having broad interpretation, because the regime of recognition of foreign bankruptcies, it has been created, but it's closed. The second question regarding applicable law. If you look at chapter 6 of part 3 of the code, so we're talking about article 1202, and all over the world we have lex ori concursus, and we have jurisdiction and applicable law. Those notions are tightly connected in Russia, and lex ori concursus is just registered in the presidium, in the decision of the presidium of the Supreme Commercial Court, and the Russian debtor of the bank purchases the right of demand from another person, and is stating that they should have the offset, which is not impossible in accordance with the foreign law, and they're coming to the Russian court to challenge the deal. What is the choice for the judge? No special collision regulations could be applied. What kind of law should be applied here? Could we apply the special provision of a foreign bankruptcy law regarding this deal? If we can do it so lex ori concursus could not be agreed and should be applied. It's a step forward, yes, definitely, but, and the but is quite big also, that lex ori concursus was established for challenging the offset transactions, because offset transactions abroad are tightly regulated. And when there is a challenge, so it's an exception of lex ori concursus, and so if you have the offset, you have to look at possible contradiction to lex ori concursus, and only in case of these two matters coinciding, we can talk about challenging that offset. And on the one hand, it's a step forward. On the other hand, it's a step backwards, because the general provision was established for very special type of legal relations. And I believe that a lot of research would be done, because Snorres Bank case, it revived the discussions among Russian experts regarding insolvency and bankruptcy matters. And a couple of words that are not reflected in the laws of the Russian Federation. First of all, it's a lack of legal tools, having the protocols of cooperation of the courts. And it's not just enforcement of the court rulings of one courts and other courts. Those should be very prompt measures, and special legal basis is needed. And then we don't have a clear division of jurisdictions. We cannot deal with the bankruptcy of foreign entities. It's impossible. Okay, immediately the offshore companies are to be created, and in Russia, assets of such debtors, they cannot be so they're out of reach of foreign bankruptcy laws and Russian bankruptcy laws. We don't apply Russian bankruptcy laws, and it's quite difficult. I don't think that our country should be a bankruptcy haven, and judicial practice is reacting at it. Oxide company, and there are a number of cases in different districts, and to be brief, in Irish courts, insolvency case was initiated, and also the procedures were initiated to challenge a number of transactions, and the assets in the Russian Federation very quickly were given as the stock of legal entities, and offshore companies became final beneficiaries. And then arbitral manager had to challenge those deals somehow. And those cases show that the Russian Federation, in the absence of special legal regulations, creates serious obstacles to recognition of foreign bankruptcy rulings, and provide the opportunities for bad faith behavior in taking the assets out of the Russian jurisdiction. Everything must be transparent. Discussions must be conducted in order to present the adequate measures, and we must at least introduce changes in the Part 6 of the Civil Code, and we must have collision regulations for transborder bankruptcies. Also, let's introduce changes into the law on insolvency and bankruptcy. Let the mechanism be quite transparent and quite clear, and also recognition of foreign judgments shouldn't be just final judgments, but should be any rulings. And the specific law was discussed for many years, and then at the final stage the work was stopped because the legal community most probably is not ready for such legal constructions, and everybody, all the entities, they looked at the center of main interests, how could standards be applied, and finally now the draft law is not discussed, and also when we have single economic space in Eurasian territory, that's when we're going to apply the experience of European Union. When we're going to have freedom of movement of labor and capital, we're also going to have a global issue of bankruptcies. There will will be close integration of the markets, and there will be parallel proceedings right away, and so on. So the problems could be there. And the prospects of some international treaty, well, that could be some ideal future, but in Eurasian economic space, well, that's quite possible. And when we're looking at different laws, draft laws, international treaties, but that's why we're meeting here in order to discuss what should be included in all those documents. If you have any questions, I will be happy to answer those. Well, I couldn't really stop you, although time is running. It's a very interesting presentation, in-depth presentation, and when we're talking about some voluntary organization, we are in the kindergarten. Well, now it's quite advanced kindergarten. We're almost in elementary school here regarding this issue. And of course, we cannot have just judicial practice. We must get legislators involved, and the legislators, they shouldn't rely on some vacuum. They should rely on profound research, foreign experience, and also Eurasian economic space that could be used for experiments, however strange it might sound, and it could be some kind of a trial ground to look at transnational bankruptcies, transnational reorganizations, and we could see, we could test it first here in our single economic space, and then now I would like to give the floor to Mr. Brooks, and I would like to ask him to tell us how transborder bankruptcies work in the U.S. Are there any local aspects there, like in Russia, or transnational, and so on?
Thank you very much. I'm pleased to be here. I'm honored to be here. And I would like to start out by simply saying I think that Ms. Mokova's comments were so good and so apropos. Her principles that she spoke of and the questions she raised, they were so good that I would like to adopt all of them as part of my presentation. And that way I can make good use of the limited time I have. Let me try to answer the question briefly. And it is this. My point of view stems from the fact that I am a bankruptcy judge in the United States. And we have a fairly elaborate, fairly detailed system of reorganizing businesses. And it's all done overseen by a court. We call it Chapter 11, but it's a process whereby we protect a business because it voluntarily chooses to file for bankruptcy, and the court protects the business so that the business can have a time and opportunity and even new, fresh financing for the purpose of undertaking a reorganization. That reorganization can be a merger, it can be a sale, it can be an acquisition. The important thing, though, to remember in our system is it's all under the protection of the court. Of course, there are mergers and acquisitions not undertaken in a court or overseen and monitored by a court, but because we have a voluntary bankruptcy system for business reorganizations, many of them seek refuge in the court so they can be protected from the creditors while they attempt to negotiate a settlement arrangement. So many interesting and useful comments have been made today, and it prompts a number of comments I would like to make. And I notice on the screen I had submitted a table of contents of a book, not a book, an article, which I was discussing transborder, transnational bankruptcies in the United States and how they are developing and how they have been developing these past several years. We passed the Model UN or UNCITRAL, United Nations Committee on International Trade Law. We in the United States adopted that. And we adopted it because it sets up an overall framework to try and carefully manage transnational or cross-border bankruptcy cases. Ms. Makova talked about, I love the term, bankruptcy tourism. It's a very clever term, and that's one of the biggest problems in cross-border bankruptcy cases. How do you manage a case with a central control judge or administrator and allow the different jurisdictions, creditors in different countries, assets in different countries, how do you get them all to work in a coordinated fashion? How can you get the authorities from the different countries to cooperate with one another, to recognize another country's decisions if there is more than one bankruptcy? For example, if there were a bankruptcy in Canada and a bankruptcy in the United States and there were assets in Russia. It can be very tricky, very difficult. And as our moderator pointed out, it becomes ever more complex because it has a transborder or a cross-border feature to it. That gives it an added layer of difficulty, an added layer of complexity. Our moderator also commented to the effect that she said that Russia is at a stage where it's in the kindergarten stage, and it has to learn much about local bankruptcy and transborder bankruptcy. Let me tell you, please, that in the United States, they are still learning how to make bankruptcy work. It is very complicated, and in an increasingly globalized economy, we're changing our law frequently. As I indicated a few minutes ago, it was just 7 or 8 years ago that we significantly amended our law, and we did it to try and deal with cross-border bankruptcies. We want to see the system somewhat organized and somewhat cooperative and somewhat accommodating one another. Now, the model law was established, and I think it has now been adopted by 20, maybe 25 countries around the globe. And it targets how you can have judges or administrators or trustees, how they can work together and how they can cooperate and how they can communicate amongst themselves in order to have a transnational, successful reorganization, whether it's going to be a merger, whether it's going to be a liquidation, or it's going to be a sale of some assets, but the retention of the main business. There's so many different ways that you can reorganize a business. When they're in financial distress, that's when they need the protection, and that's why multiple countries, Russia, the U.S., the EU, why we need some kind of framework so that we can cooperate. Remember, the purpose of the reorganization laws in Russia and the U.S. and everywhere else is to try and save a business, if it's feasible and economically sensible to do so, and to save jobs, and to maintain or retain a tax-paying entity. So there's lots of benefits there. When we passed our model law, which we call Chapter 15, it's just the name, we set up a regime, a framework, architecture, so that bankruptcy cases in other countries can access the United States courts and let the U.S. courts facilitate or complement or aid foreign courts. So if there were, for example, to be a main business in Russia that had a bankruptcy in Russia, then the Russian court or the Russian arbitration administrator could apply to the U.S. court. The U.S. court has an obligation to recognize and approve a foreign representative in a foreign bankruptcy in most all circumstances. Once the American court recognizes the foreign representative, that the foreign representative is acting on behalf of the business that is in the bankruptcy process, then they can go into the U.S. court system. They can file just about anything they wish. They can file lawsuits. They can protect assets. They can stop all creditors from trying to take assets that might be located in the United States. The idea is to have a main proceeding, say in Russia, or in Canada, or in Germany, and then have other minor proceedings, ancillary proceedings, all of which try to cooperate with the main proceeding. It gets pretty involved. Ms. Mokova described that it gets rather complex and technical, but the fact that many countries are continuing to use the model law is a testament, is a comment that it works, and it works to a certain degree. It's not perfect. None of our bankruptcy laws are perfect, but we're developing them, and global economy, global lending, global suppliers and creditors demand there be something sensible so that when a company is in financial distress, that it has the architecture to try and work its way out. Now, this usually applies to business reorganizations, where you try to restructure the business, but it can also apply in liquidations if there are assets in different countries, if there are creditors in different countries, if there are offices of the business in different countries. So because of time, I don't wish to overstay my welcome, but if we have questions and answers, I would be happy to deal with some of the issues, or I'd be happy to give you a copy of my article.
Спасибо большое, господин Брукс. Действительно.
Thank you, Mr. Brooks. So you've made a kind of a bridge for us, and I can now state something which is not typical of the Russian legal thinking. The reorganization mechanism is used to protect the company against creditors, for example, because usually we consider bankruptcy cases as the cases of a company in financial distress, and reorganization may be a way out or may not be a way out. So this is a kind of a bridge between these two parts of our panel, which you have made, Mr. Brooks, and now I'd like to give the floor to Mr. Keyselian. And we stress that one of the key issues of transborder reorganization is search for property across the world, and there should be unified process, and Mr. Keyselian specializes in it. Please, you have the floor, sir.
Everyone. I'm a lawyer in Brazil. I do a lot of appellate work before the appellate court, and I would try to bring here today a little bit of my experience before the Brazilian courts, doing the international asset recovery that we do day by day, daily basis. Well, first of all, I'd like to say that Brazil is still haven't adopted the UNCITRAL model law regarding solvency, but we are getting there. Chris Redman, who is here in the second chair here, he's helping the Brazilian authorities to get it done. Maybe by next year we'll be already adopted the UNCITRAL model law. Well, since I'm always on the side of the trustee, always representing the creditors, I always have in mind two issues that for me is a core issue on the bankruptcy. First one is to preserve the asset, whatever the asset is, and extract the most value of the asset. And when you face fraudulent bankruptcy, is to find the asset. So these two values that I'm always looking at. And it is very hard for us to do our work when you face a jurisdiction, offshore jurisdiction, that hasn't adopted the model law, because it creates a lot of difficulties to bring the claims and to exercise the powers as a trustee. We had a case now in Brazil. Is an international airline that went bankrupted. It did a lot of international flights as well. That's why this company had some accounts even in Switzerland. And the biggest unsecured creditor that was supposed to, it is subject to the Brazilian court. He filed his claim before the Brazilian court, but he's a sophisticated creditor. He has a lot of money, and he tried to seize some assets of these airlines in Switzerland, and he was able to freeze around $25 million. The Brazilian court tried to talk to the Switzerland court, send official letters asking for the money, to send the money back to Brazil. We didn't hear from the Switzerland courts. So we were about to lose the money for this unsecured creditor from Delaware, in spite of not paying the labor creditors in Brazil. For our lucky, this Delaware entity had some economic interest in Brazil. It had another companies in Brazil. So instead of sending a letter rogatory to the Switzerland courts asking for the money, we asked for an injunction before the Brazilian judge, ordering this Delaware company not to touch the money, subject to a fine of $100,000 a day. We got the injunction, and now we are in a corner. If the Delaware company touch the money, he will pay us the fine. And we are Brazilians, we are very creative on how to do it the way. But if we had a formal channel, a more easy channel to talk to Switzerland, that this wouldn't be an issue. And I can tell you that we are spending a lot of human resource on this fight, a lot of money, and this makes our work less productive. Well, regarding the part of the bankruptcy where you face a fraud and where there is a lot of assets diverted from offshore, we used to have this culture in Brazil that once the money is offshore, nothing could be done. So if you look at the Brazil numbers, you see huge bankruptcy companies like $2 billion debt, and the controlling minds of the company very rich in their boats offshore outside Brazil, and the trustee in Brazil didn't know how to do it, how to get there. And the insolvency in Brazil is a very powerful tool. Once the trustee steps in the company, he can ask for the bank records in Brazil and find where the money went for. And there is this case in Brazil that I would like to mention because it's the biggest bankruptcy case regarding a bank in Brazil. We were able to trace the money in Brazil to an offshore account belonging to a Uruguayan company, and the account was held in Miami. We filed the Chapter 15 mentioned by the Judge Brooks. We filed the Chapter 15 in Miami. The trustee were recognized in Miami. We were able to ask for the Miami bank, the records. Then we could trace the money to another bank. And then we could relate this another account to an offshore company entity in Cayman. So we went to Cayman. We asked for a disclosure order. We found out who was the UBO before, the ultimate beneficial owner before this entity. And then we found out that the UBO was the controlling mind of the bank. And the money that he sent to this offshore company was sent back to Brazil through increase of capital in another company. And he built a house worth 400 million reais. So with this kind of tools that the ancestral model law regarding insolvency gave us, we were able, on the last 4 years, to freeze more than $1.5 billion for the creditors in Brazil, only in 3 cases. It's a very powerful tool. It's something that the whole community of practitioners has to be worried about and has to put effort to implement around the world. Once the legal system has to measure up with the common practice on trades. That's it. If somebody has any question about soccer, I'll be happy to talk to you afterwards. Спасибо.
Спасибо большое, господин Кисельян. Особое спасибо.
Thank you. Thank you. Thank you. That we are moving towards Brazil, you still have come here, the other way around. So we have finalized our discussion. If you have questions, you're welcome. Or any comments or questions. Take a microphone, please. Take a microphone.
Thank you. I have a comment and a question both. The ancestral model law was originally developed from a concept of where you have a bankruptcy that there are assets in numerous jurisdictions, that there should be cooperation among countries so that you have a common result, you reduce the cost of the overall insolvency proceeding, and then increase the ultimate payment to creditors as part of the process. Now, that process works in a fashion that in some situations, some countries are going to have no assets at all, but they're going to share in the proceedings because they're part. So countries have to trust each other as part of the process to work together, both from a court system, court communication system, and also cooperation of the assets. With that background, the question I have is this. In order for countries to share with other countries and turn over assets that they could ordinarily utilize for themselves or for their creditors, they have to be comfortable that in similar situations, they'll be treated the same way if they have substantial obligations but no assets in those countries. So it has to work on an overall basis. Generally, as part of the process that Judge Brooks very accurately related, one of the issues that a court in the United States looks at in whether to grant recognition is if there's no model law in the other country, whether there's going to be comity. Will a court look at the fact that that country would treat the United States in the same fashion as they're being requested? And the only way to determine that is 2 factors. One is if the model law has been adopted, because that's a clear intention of what is the country's statement is, or secondarily, whether there's been a long pattern of cooperation and turnover. And my question is, with that background, is Russia prepared to put into legislation or put into some kind of definitive process a clear statement that they would recognize other countries? Because part of the problem, it sounds like, in legislation right now, that you can't, it's not easy to share assets or participate in cross-border cases as part of the process. The model law would allow that. So, you know, It sounds like you're moving forward, but the issue is Russia, do you believe Russia's prepared to modernize, update its laws to address these issues so other states around the world will have the comfort that they'd be treated in the same way as if a request was coming from Russia to other countries?
Yes, so we have Russia in view and model ancestral law. It is not incorporated in Russian legislation. That's the first thing. And there's a draft federal law dealing with transborder bankruptcies, which is based on the model ancestral law on transborder insolvency. And the key points which deal with cooperation of courts, proceedings, the information disclosure to foreign creditors, etc., etc. So all this is covered by the draft federal law dealing with insolvency, or transborder bankruptcies. So as to a special feature of the Russian Federation, then it is the will to go its own way. So in certain cases it is justified. In others, we believe that we should understand all legal consequences if we make a choice like this. What I have in mind is that though all the key points of the model law are incorporated in the federal draft law on the transborder insolvency, they were still different from the original. So when we discuss the international experience and its implementation based on the ancestral model law, and the way the Russian Federation is going to regulate it, we can say that our approaches do not coincide because we do not reproduce the model law in our draft law on transborder insolvency.
And each time we talk about the court cooperation and access to foreign assets and protection of local creditors' rights when these assets are not located in the territory of the state concerned, then I have already mentioned this, the world experience gained in this case, they sometimes are not fully incorporated in this draft federal law. Today we just suspended this work. This means that we are waiting for the comments in order to study further this topic. Those experts dealing with the drafting of this law, they said that let's look into the foreign experience, to the results of implementation of their practice, but that was quite a novelty for many ministries and agencies in Russia. That is why we need some time, more time, to digest these results. Otherwise we failed in completing this work quite successfully, or creation some kind of legal tool to govern this topic. If you don't mind, I would like to add that in order to make some progress in Russia in cross-border insolvency and cross-border reorganization, we need to develop the infrastructure from a legal point of view, from a court practice point of view, and we are moving gradually towards this progress. But cross-border insolvency, as it was rightly mentioned, here we see the underlying question, the political confidence, which applicable to cross-border insolvency issues. This issue is very important. I agree with Alyona, and of course we need to move forward, showing some political will. But first we need to address the most important issue, which is the creation of proper infrastructure. And after that we need to look into the further secondary issues. So much work awaits us, and this is the confirmation of today's session. So we are moving towards this issue. Any questions? Thank you very much. Thank you for being with us, and we just finished quite on time. Thank you.